Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about discrimination in child protection laws. Cases that should have gone to the Supreme Court of Canada, but didn't. An Afro-Indigenous person in Vancouver sued the Vancouver Aboriginal Child and Family Services Society, alleging discrimination, that the society had wrongly got involved in child apprehension proceedings where there was discriminatory conduct against this individual, specifically their cultural beliefs as not just an Indigenous person, but also a person of African descent, were used against them in the child protection regime, and ultimately argued, and successfully, that there was discrimination in the manner in which the child apprehension laws were carried out. The society, for its part, argued that effectively, if we are to use anti-discrimination concepts in child apprehension legislation and child apprehension cases, it does pose a greater risk to children because what might be culturally acceptable in one culture might not be something that is actually safe for children in Canadian society. And this raises a very important issue of, again, the balancing of rights and the balancing of different interests. On the one hand, you have the interests of the child. You also have the interests of child protection societies run by Indigenous people who are dealing with at least part Indigenous children. And you also have the interests of individuals to participate in their culture and engage in their lives in a way that makes sense to them. And this case is something that the Supreme Court of Canada really ought to have gotten into. Child apprehension is one of the areas that has the most potential for harm. It can have long-term harm to family relationships. It can have long-term trauma for the children who are involved in the system. It can do long-term harm in terms of placement and where children end up and degradation of relationships with family members. So shouldn't the Supreme Court of Canada take something like this with an angle that has never really been considered in these types of cases before seriously and agree to grant leave to the matter? This is the exact type of thing we're supposed to have a Supreme Court of Canada for issues of national importance, of public importance that haven't been legally considered before. And unfortunately, the Supreme Court of Canada really missed the very nuanced but very significant issues that now, without Supreme Court of Canada guidance, may potentially lead to a situation where further harm is caused to children or where harm is prevented to children because of a situation where the law is not being interpreted necessarily in a fair manner, even if it's potentially discriminatory. Hopefully, the Supreme Court of Canada doesn't have to get involved in a situation where there has been actual harm to a child, and that they can hear a case like this and describe how Section 15 equality rights play in the child apprehension process for future guidance for courts. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Please like, subscribe, share with your friends.